December 3, 1947, Nuremberg, American zone of occupation. The heating pipes in Building 6 of the Palace of Justice knock and hiss in a rhythm she's learned to ignore. Magda Reiner sits at a scarred oak desk beneath a single bulb, the kind that flickers when trucks pass outside. She is 24. Her fingers are stained purple from the carbon paper she's been handling since dawn. The room smells of mimeograph fluid, damp plaster, and the particular staleness of documents that have traveled in sealed crates across a shattered continent. On the desk before her, a stack of testimony transcripts, each page stamped with the eagle of the Allied Control Council. On the floor beside her chair, a wire wastebasket half full. She has been told her job is administrative, clerical, a matter of organizational consistency. The transcript in her hands is 18 pages long. It details events that occurred in a clearing near Minsk in October 1943. The witness is a woman named Irina Volkova, formerly a lieutenant in a Soviet medical battalion. The language is clinical, the way all testimony becomes after translation. Detained, separated from male combatants, transporting to auxiliary holding area. There are no screams in the transcript. There is only the structure of sentences, the placement of commas, the bureaucratic necessity of turning experience into evidence. Magda has read 4 others like it this morning. At the bottom of the page, a handwritten notation in English, category reassignment, non-combatant incident, refer to file series WD civilian. She knows what this means. She has done it 11 times this week. The transcript will not be entered into the war crimes docket. It will not be read aloud in a courtroom where journalists sit with shorthand pads and the world listens through radio microphones. It will be transferred to a separate archive, one designated for displaced persons, refugee claims, and what the British liaison calls collateral documentation. It will be filed. It will be lost. Her instructions are clear. They came from a U.S. Army major whose name she was told to forget. The reasoning was explained to her once, in a windowless office that smelled of floor wax. The tribunal is overburdened. The caseload is unmanageable. The priority is command responsibility, policy-level criminality, crimes against entire populations. Individual incidents of misconduct, however regrettable, fall outside the mandate of the International Military Tribunal. There are other venues. National courts, reparations commissions. It is a matter of scope, not suppression. She was told this in a tone that expected understanding. Magda places the Volkova transcript on the left side of her desk. She opens the logbook, a ledger with blue-ruled columns, and enters the case reference number under the heading Transferred. She writes the date. She initials the entry. Then she takes a red wax pencil and strikes a single diagonal line across the reference number in the original intake registry. The line is thin, neat, almost delicate. Outside, in the courtroom 3 floors above, the trial of the Einsatzgruppen commanders is entering its 5th week. The public galleries are full. Photographers wait in the corridors. The evidence presented there is overwhelming, systematic, industrial in its documentation. Gas vans, execution pits, casualty reports filed in triplicate. The kind of crimes that are undeniable because the perpetrators recorded them with the same efficiency they used to commit them. The crimes Magda is erasing are smaller. That is the word she hears used, smaller. They lack the architecture of genocide. They are not enshrined in policy memos or approved at ministerial level. They occurred in basements and barns and medical tents. They were committed by men whose names appear nowhere in the chain of command, men whose superiors will say they acted alone, outside orders, beyond control. And the women who survived them are, in the language of the tribunal, insufficiently representative. They are Soviet. They are Polish. They are partisans. Their testimony is complicated by their status as combatants, by the fog of irregular war, by the fact that no memo exists authorizing what was done to them. So the memos become the truth, and the truth becomes what can be proven in a courtroom built for a different kind of crime. Magda takes the next file from the stack, another transcript, another woman, this one from a holding camp outside Smolensk. The details are different. The handwritten notation at the bottom is the same. She has begun to notice patterns. The files that reach her desk share certain characteristics. The victims are always female. The The perpetrators are rarely named. The incidents are always described as isolated, opportunistic, beyond the scope of organized policy. None of them will be read into the record. None of them will be prosecuted. And in 10 years, when historians sift through the archives of Nuremberg, they will find volumes of testimony about starvation and forced labor and mass execution. But they will find almost nothing about this. Because Magda Reiner, clerical assistant to the Documentation Division of the Office of the U.S. Chief of Counsel, is making it disappear. She did not choose this work. She needed employment. She speaks 3 languages. She survived the war by being useful. And now, in a room that smells of ink and old wood, she is useful again. The heating pipes knock, the bulb flickers, she opens the logbook and writes the next number. The system that brought Magda Reiner to that desk did not begin in Nuremberg. It began in the autumn of 1945, in London, in a series of meetings where men in wool suits debated the architecture of justice. The International Military Tribunal was unprecedented, 4 Allied powers sitting in judgment over a defeated nation, applying laws that had not existed when the crimes were committed. The legal framework was fragile. The political stakes were immense. And the volume of evidence was incomprehensible. By January 1946, the Allies had captured over 100,000 tons of German documents, railways records, Wehrmacht orders, SS personnel files. Ministries had burned what they could, but bureaucracies are difficult to destroy completely. What remained was a paper trail of such density that it threatened to collapse under its own weight. The tribunal needed a system. It needed categories. It needed a way to separate the prosecutable from the merely criminal. The London Charter, signed in August 1945, defined 3 categories of punishable offences: crimes against peace, war crimes, and crimes against humanity. Each had subcategories. Each subcategory had evidentiary thresholds. The prosecutors, American, British, French, Soviet, had to demonstrate not just that crimes occurred, but that they were systematic, that they reflected policy, that they connected to the leadership sitting in the dock. Individual acts of violence, however brutal, were insufficient. The tribunal was not built to punish soldiers. It was built to dismantle a regime. This created a sorting problem. In the document center, established in the Palace of Justice, over 400 clerks worked in shifts processing evidence. They translated, they indexed, they determined relevance. The chief American prosecutor, Robert H. Jackson, had promised the world a trial based on documentary proof, not selective testimony. He wanted the Nazis convicted by their own words. This required an army of typists, interpreters, and archivists who could turn chaos into courtroom exhibits. Magda was hired in March 1947, part of a second wave of German nationals brought in to accelerate processing. The first wave had been vetted Allied personnel, emigres, intelligence officers, lawyers, but by 1947, the initial trials were complete. Goering was dead. Von Ribbentrop was dead. 12 men had been hanged in the gymnasium of the Palace of Justice, and the world had watched. Now came the second phase, the subsequent proceedings, the smaller tribunals, the cases against industrialists and bureaucrats and the middle managers of atrocity. The archives were still full. The workload had not diminished. The Americans needed clerks who could read German legal documents, understand military terminology, and work cheaply. Magda had grown up in Stuttgart. Her father had been a low-level official in the postal service, a man who joined the party in 1937 because employment required it. He died in an air raid in 1944. Her mother had survived the war selling ration cards on the black market. Magda herself had worked as a translator for the occupation forces in Stuttgart before being transferred north. Her denazification certificate was stamped Category IV, Mitteleufer, follower, exonerated. She was told her role was technical. She would assist in categorizing evidence according to the evidentiary matrix established by the prosecution. Certain types of testimony, those describing singular, unwitnessed, or non-systematic acts, were to be transferred to a separate case file system. This system was described to her as a kind of secondary archive, one that national courts or future investigations might access. It was not suppression, it was triage. The reality was more precise. By late 1946, The Allies had collected over 2,400 depositions from female witnesses, Soviet, Polish, French, Yugoslav. Many described sexual violence. Many described conditions in auxiliary camps, makeshift detention sites, interrogation cellars. These testimonies were vivid, specific, and legally problematic. The women had often been combatants, partisans, medics attached to irregular units. Under international law as it existed in 1947, their status was ambiguous. The Geneva Conventions of 1929 extended protections to prisoners of war, but partisans were not uniformed combatants. The German defense attorneys argued repeatedly that women captured outside the framework of regular armed military engagement were not entitled to POW status, which meant that crimes committed against them were not war crimes. They were, at most, domestic offenses under German law. The prosecutors knew this. They also knew that relitigating the status of every female partisan would paralyze the tribunal, so a decision was made, never formalized, never written into a memo, but communicated through the chain of supervisors who managed the document center. Testimony describing sexual violence against female combatants would be processed separately. It would not be excluded. It would simply be moved. Magda received her instructions in April. A U.S. Army captain named Harrow explained the protocol. He had a narrow face and wire-rimmed glasses, and he spoke to her in slow, deliberate German. He used the word streamline. He used the phrase evidentiary relevance. He did not use the word bury. But he showed her the logbook, and he showed her the notation system, and he told her that she would be handling approximately 30 to 40 cases per week. She asked once what would happen to the files after transfer. He told her they would be preserved, they would be available, they would remain part of the historical record. He did not tell her where. Within 3 weeks, Magda had processed over 120 cases. She learned to recognize the testimonies before she finished the first page. Certain phrases recurred: separated from unit, auxiliary interrogation, medical examination by non-medical personnel. The language was formulaic because the translators had been instructed to standardize. The horror was structured into grammar. And every day, she took her red wax pencil and struck the reference numbers from the active docket. The heating pipes knocked in rhythm. The mimeograph machines clattered in the next room. Outside, in the courtroom, men in headphones listened to testimony about Zyklon B and railroad schedules. And in Building 6, on the 3rd floor, in a room lit by a single bulb, Magda Reiner erased women from the official history of the war. She began to dream about file numbers. The first case Magda could not forget arrived on a Thursday in late April. The transcript was thicker than usual, 47 pages, typewritten in English with handwritten annotations in Russian along the margins. The witness was identified only by a reference number, DP 4712, F displaced person, female. The deposition had been taken at a refugee processing center in Bad Reichenhall, near the Austrian border, in February 1947. The interviewer was a Red Army legal officer whose name had been redacted. The woman had been a sergeant in the 214th Rifle Division. She was captured in July 1942 during the German encirclement at Voronezh. She and 11 other women, medics, signal operators, a political officer, were separated from the male prisoners and transporting west in a covered truck. They were told they were being moved to a re-area interrogation facility. The drive took 6 hours. When the truck stopped, they were in a forest. There was no facility. There was a barn, a farmhouse, and a wooden shed that had been used for storing potatoes. The transcript described what happened over the next 9 days in the kind of language that legal systems use when they cannot afford emotion. Detained without formal classification, subjected to non-standard interrogation procedures, held in conditions inconsistent with Geneva protocols. The woman described the shed, the dirt floor, the absence of latrine facilities, the schedule. She described the men who came, not their names, she never learned their names, but their ranks: a lieutenant, 2 sergeants, once a captain who wore a Wehrmacht uniform but spoke with a Bavarian accent and carried a leather dispatch case. She described the medical officer who examined them on the 3rd day. He wore a white coat over his uniform, he had a clipboard, He recorded their names, their units, their physical condition. He asked if any of them were pregnant. One woman said yes. The medical officer made a notation. That woman was taken to the farmhouse. The witness never saw her again. On the 9th day, a different officer arrived. Older, clean-shaven, he carried orders. The women were loaded back into the truck and driven to a railhead. From there, they were sent to a labor camp near Königsberg, where they were registered as civilian detainees. The witness survived 2 years of forced labor in a textile factory. She was liberated by Soviet forces in April 1945. She spent 6 months in a Red Army filtration camp, where returning prisoners were screened for disloyalty. Then she was released. Then she tried to go home. Then she found out her village no longer existed. At the bottom of the transcript, the notation, insufficient command nexus, no documentary linkage to OKW or OKH policy, recommend transfer to DP refugee claims. Magda read the transcript twice, then she opened the logbook. She wrote the reference number, she made the notation, she took the red wax pencil. But this time, before she struck the line, she did something she had not done before. She made a copy. The mimeograph room was on the 2nd floor. It was staffed by 2 German women in their 50s who operated the machines with the efficiency of factory workers. Magda told them she needed a duplicate for cross-referencing. They did not ask questions. The machine clattered. The pages emerged damp and smelling of solvent. She folded the copy and put it in her bag. That night in the boarding house where she rented a room on Fuhrerstrasse, she read the transcript again. She had no plan. She did not know what she would do with it. But she could not let it vanish into a file system she had never seen and suspected did not exist. Over the next 6 weeks, she copied 23 more. She was careful. She rotated which mimeograph room she used. She never copied more than 2 in a single day. She varied her explanations, clerical error, supervisor request, indexing backup. No one questioned her. The document center processed thousands of pages daily. A few duplicates were invisible in the noise. She kept the copies in a cardboard box beneath her bed. She did not read them again. She did not organize them. She simply took them home, one by one, and hid them. By June, the pattern she had suspected became undeniable. The testimonies shared structural similarities. The women were always captured in frontline zones, Crimea, Byelorussia, Ukraine. They were always separated from male prisoners within hours. They were always transporting to temporary holding sites, barns, schoolhouses, abandoned estate buildings, rather than formal POW camps. They were always held for short periods, 4 days, a week, 10 days. Then they were either killed or transferred to labor camps and reclassified as civilians. None of the testimonies included perpetrator names. The women remembered ranks, sometimes units, sometimes physical descriptions, but the men who detained them left no paper trail. There were no orders authorizing their separation, no transport logs recording their movement, no camp registries listing their arrival. The machinery of documentation that had condemned the architects of the Holocaust, those meticulous records of train schedules and gas chamber capacities, did not exist for these crimes. And without documentation, there was no command responsibility. Without command responsibility, there was no case. Magda began to notice something else. The testimonies that reached her desk were not random. They had been pre-sorted. Someone, earlier in the chain, had already decided which depositions would be forwarded to active prosecution and which would be routed to her office. She was not the beginning of the suppression. She was the final step. She asked her supervisor, a brittle woman named Clerk, who had worked in the Berlin Municipal Archives before the war, where the transferred files were stored. Clerk looked at her for a long moment. Then she said, "That is not your concern." Magda asked if the files would be available to researchers after the tribunal concluded. Clerk said, "This is administrative work. You are not here to ask questions." Magda did not ask again. But in early July, she saw something that clarified everything. She was walking past the offices used by the Soviet prosecution team when she noticed a clerk she recognized, a Ukrainian woman named Olna who worked in the translation pool. Olna was arguing with a Soviet officer in the hallway. Her voice was low, but her hands were shaking. Magda caught fragments. They told us it would be evidence. They said it mattered. Now they say it is not relevant. The officer said something Magda could not hear. Olna went silent. Then she walked away, her face blank. Magda understood then that she was not alone, that other women in other offices were performing the same task, that the system was not accidental, it was designed. That night she copied 4 more transcripts. She no longer pretended she was doing it for cross-referencing. She simply walked into the mimeograph room, placed the pages on the glass, and ran the machine. The women who operated it stopped asking. The box beneath her bed grew heavier. The turning point came in August, when Magda was reassigned to a different section of the archives. She was not told why. One morning, Köhler informed her that she would be working in the Reference and Verification Unit, a smaller office on the 4th floor that handled cross-checks between testimony and captured German military records. The work was more technical. It required matching witness statements against Wehrmacht personnel files, unit war diaries, and operational logs. The goal was to corroborate testimony with documentary evidence, to prove that the accused had been in the locations they were alleged to have committed crimes. It was here that Magda discovered what had been d. 1. The Reference and Verification Unit maintained a master index, a card catalog system that linked every piece of testimony in the tribunal's possession to corresponding German records. Each card listed the witness reference number, the date and location of the alleged crime, and the relevant German units that had been operational in that area. If corroborating documents existed, deployment orders, situation reports, supply requisitions, the card included file references. If no documents existed, the card was marked with a red stamp, no German source material available. Magda's task was to process cards that had been flagged for secondary review. These were cases where initial searches had failed to locate supporting documents, but where prosecutors believed records might still exist in uncatalogued caches. The Americans had captured entire rail cars full of Wehrmacht files in the final months of the war. Much of it had not yet been indexed. She began to notice a pattern in the cards she was assigned. Nearly all of them involved female witnesses. Nearly all described incidents in rear area zones, behind the front lines, in occupied territory, in regions controlled by security divisions and field gendarmerie units. And nearly all had been marked no German source material available. But when Magda cross-referenced the dates and locations with the unit war diaries she had access to, she found something different. The records existed, they simply described events in different language. On August 14th, she pulled a card for a Polish woman who had been detained near Elwau in October 1941. The woman's testimony described being held in a commandeered school building for 6 days. The card noted that no German documents referenced the detention, but Magda found the war diary of the 213th Security Division, which had been responsible for rear area control in that sector. The entry for October 22, 1941, included a single line, Bandenhelferinnen, 21 Frauen, Sonderhaft, bandit helpers, 21 women, special detention. No further details, no names, no disposition, just a bureaucratic note that 21 women had been placed in special detention, a term that had no formal definition in Wehrmacht regulations. Magda pulled another card, a Soviet nurse captured near Smolensk in September 1942. The testimony described a holding area in a converted dairy. The war diary of the 286th Security Division recorded Freischülerinnen, Vorlieufige Verwahrung, 12, female irregulars, temporary custody, 12 women. Again, no further information. The women appeared in the record as a number and a classification, then they vanished. She began searching systematically. Over the next 3 weeks, she found 17 separate references in German military diaries that aligned with testimonies that had been marked as uncorroborated. The entries were brief. They used euphemistic language, bandit helpers, female irregulars, suspected partisan auxiliaries, temporary custody, special handling. None of the entries specified what happened to the women. None mentioned interrogation. None mentioned transfer to POW camps. The women simply appeared in the logbooks as administrative footnotes, and then the record moved on. But the entries proved something critical. The detentions had been recorded. The German military had documented these women, which meant the crimes committed against them had occurred within a system under the knowledge of commanders who kept daily logs of their operations. This was the evidence the tribunal needed, proof that the abuse of female prisoners was not the work of rogue soldiers acting outside the chain of command, but part of a broader apparatus of rear area security operations conducted by regular Wehrmacht units. Magda drafted a memo. She typed it on a Thursday afternoon in the small room where the clerks kept the reference files. She addressed it to the Deputy Chief Counsel for War Crimes, an American attorney named Marcus. She listed 12 examples where German records corroborated testimonies that had been classified as uncorroborated. She noted the pattern of euphemistic language. She argued that the cases warranted re-evaluation. She placed the memo in the outgoing correspondence box. 2 days later, Köhler called her into the office. The memo was on the desk between them. Köhler's face was rigid. She asked Magda if she understood the scope of her position. Magda said she did. Köhler said, "Your task is to process materials as directed, not to conduct independent analysis, not to offer recommendations, not to question decisions made by attorneys with years of legal experience." Magda asked if the cases would be reviewed. Köhler said, "The evidentiary standards of this tribunal are not your concern." Magda asked if the German records she had found would be submitted to the prosecution. Köhler folded her hands. "Those records describe rear area security operations. They are not evidence of criminality, partisan acti." Vitti posed a legitimate security threat. The Wehrmacht had a lawful basis for detaining suspected auxiliaries. What may or may not have occurred during detention is a separate matter, and without direct testimony linking specific acts to specific commanders, such cases fall outside prosecutorial scope. Magda said the women gave direct testimony. Köhler said the women were partisans. Magda said nothing. Köhler leaned forward. Her voice was quieter now, almost gentle. "You are young. You do not understand the constraints we are operating under. The tribunal cannot prosecute every crime. It must focus on systematic atrocities ordered at the highest levels. Individual misconduct, however regrettable, is the responsibility of national courts. Germany will have its own legal system again. These matters will be addressed through appropriate channels." Magda thought about the boxes of transcripts beneath her bed. She thought about the women whose reference numbers she had memorized. She thought about the phrase, appropriate channels. She asked when. Köhler stood, "That will be all." Magda returned to her desk. She did not submit another memo, but she did not stop copying transcripts. By the end of August, the box beneath her bed contained 73 depositions, and Magda Reiner, clerical assistant, began to understand that she was not documenting a crime. She was documenting a cover-up. The subsequent proceedings tribunals concluded in April 1949. By then, the Palace of Justice had processed cases against doctors, judges, industrialists, and the commanders of the Einsatzgruppen. 177 defendants had been tried. 12 had been sentenced to death. The world had moved on. The Berlin airlift dominated headlines. The division of Germany was hardening into permanence. The Western Allies were no longer interested in prosecuting the defeated. They were interested in rebuilding them. Magda was laid off in May. She received 2 weeks' notice and a severance payment of 400 Deutschmarks. The document center was being downsized. Most of the German clerks were let go. The remaining archives would be maintained by a skeleton staff of Allied personnel. Köhler shook her hand and told her she had performed her duties admirably. There was no mention of the memo, no mention of the transcripts. On her last day, Magda asked what would happen to the transferred files, the ones she had reclassified, the testimonies that had been moved out of the active docket. Köhler told her they had been shipped to a storage facility operated by the U.S. Army. They would be preserved as part of the historical record. Researchers would have access, eventually, once the materials were declassified. Magda asked where the facility was located. Köhler said she did not have that information. Magda never found out. In 1968, a historian researching Soviet POW testimony requested access to the tribunal's auxiliary archive. He was told that no such archive existed. The transferred files had never been catalogued. There was no master index, no retrieval system. The U.S. Army acknowledged that materials had been placed in storage in 1949, but the location of that storage was not recorded. The files had been moved multiple times, from Nuremberg to Berlin, from Berlin to Frankfurt, from Frankfurt to a military depot in Virginia. At some point, they had been reclassified as administrative documents rather than evidentiary materials. At some point, they had been deemed non-essential. At some point, they had simply vanished. When the National Archives opened the Nuremberg records to researchers in the 1970s, they contained over 330,000 pages of testimony. Fewer than 200 pages concerned sexual violence against female prisoners, and none of those pages had been entered into evidence during the trials. The women whose voices Magda had erased were gone. Not from history, they had never entered it. But Magda had kept the box. She moved 5 times in the 2 decades after Nuremberg. She married in 1951 a mechanic named Dieter who had lost an arm at Stalingrad. She worked as a secretary, then as a bookkeeper for a textile firm in Munich. She had 2 children. She told no one about her work at the tribunal. It was not unusual. Many Germans did not speak about those years. The war was a wound, and silence was how it healed. But the box moved with her, from the boarding house to a small apartment in Fürth, from Fürth to a rented house in Augsburg, from Augsburg to Munich. She kept it in closets, under beds, in the back of storage cupboards. She did not open it. She did not reread the transcripts, but she did not destroy them. In 1971, she saw a newspaper article. A West German historian named Wilhelm Hoffmann had published a study on the treatment of Soviet POWs. The study relied on Wehrmacht records and survivor testimony collected through Soviet archives. It was comprehensive, meticulous, devastating. It documented starvation, forced labor, summary executions. It noted, in a single paragraph, that female prisoners had been subjected to additional abuses, but Hoffmann wrote that documentation was sparse and survivor testimony difficult to verify. Magda wrote him a letter. She did not explain who she was. She did not describe her role at Nuremberg. She simply stated that she possessed 73 depositions given by female prisoners between 1946 and 1947, and that these depositions had been excluded from the tribunal proceedings. She asked if he would be interested in reviewing them. Hoffmann responded 3 weeks later. He asked where the documents had come from. He asked if they were authenticated. He asked if Magda understood the legal implications of possessing tribunal materials. She did not reply. Hoffmann wrote again, more carefully this time. He said he did not need to know the source. He said the materials could be provided anonymously. He said they could be deposited with an academic institution or a research archive. He said he would handle the authentication. Magda thought about it for 6 months. Then, in March 1972, she packed the 73 transcripts into a postal box and mailed them to the Institute for Contemporary History in Munich. She did not include her name. She did not include a letter. She simply sent the documents, and then she went back to her life. The Institute received the box in April. The archivist who opened it was confused. The transcripts were clearly genuine. The paper was tribunal stationery. The typeface matched Allied military typewriters. The reference numbers aligned with known Nuremberg case file systems. But there was no record of these depositions in the official archive. The Institute contacted the National Archives in Washington. The National Archives confirmed that the reference numbers were valid, but stated that the associated files had been classified as missing since 1952. Hoffmann included 17 of the depositions in the second edition of his study, published in 1974. He noted in the preface that the materials had been provided anonymously. He noted that they revealed a systematic gap in the evidentiary record of the Nuremberg tribunals. He noted that attempts to locate the remaining depositions referenced in tribunal intake logs had been unsuccessful. The second edition sold poorly. It was an academic work, dense and grim, published by a university press with limited distribution. The revelations it contained, that the Nuremberg prosecutors had deliberately excluded testimony of sexual violence against female combatants, did not become a scandal. There were no headlines, no parliamentary inquiries, no demands for reopened investigations. The war was over. The perpetrators were old men or dead. The victims were scattered, most of them behind the Iron Curtain, unreachable, their testimonies frozen in archives Hoffman could not access. And the legal argument that had been used to exclude their testimony in 1947, that female partisans were not entitled to Geneva Convention protections, remained, technically, valid under international law as it existed in 1974. It would take another 2 decades before the International Criminal Tribunal for the former Yugoslavia formally recognized sexual violence as a prosecutable war crime under international humanitarian law. And even then, the recognition came not because the law had changed, but because the political will to ignore it had finally eroded. Magda Reiner died in 1983. She was 60 years old. The cause was lung cancer. Her children, sorting through her belongings, found no evidence that she had worked at Nuremberg. No documents, no photographs, no letters. She had erased herself as thoroughly as she had erased the women in the transcripts. But the box had survived, and 17 testimonies had entered the historical record, not as evidence, not as justice, but as proof that someone, somewhere, had been listening. The silence that followed Nuremberg was not passive. It was constructed, maintained, and defended by legal systems that valued procedural consistency over moral reckoning. The decision to exclude testimony of sexual violence against female combatants was never reversed. It was never formally acknowledged. It simply became part of the institutional architecture of postwar justice, a foundation so deeply embedded that later generations of lawyers and historians would assume it had always been inevitable. But inevitability is a lie told by systems to excuse their failures. The international legal framework that emerged from Nuremberg enshrined a hierarchy of victimhood. Crimes against civilian populations, genocide, mass deportation, extermination, were recognized as offenses against humanity itself. Crimes against uniformed soldiers in formal combat were covered by existing conventions, but crimes against those who existed in the ambiguous space between partisans, resistance fighters, women who took up arms without the sanction of a recognized state, fell into a legal void. They were neither civilians nor soldiers. They were irregular, and irregularity, in the language of law, meant expendability. The 1949 Geneva Conventions, drafted in the immediate aftermath of the tribunals, attempted to close some of these gaps. Common Article 3 extended basic protections to all persons taking no active part in hostilities, including members of armed forces who had laid down their arms. The Fourth Convention expanded protections for civilians in occupied territory, but the conventions did not retroactively apply to crimes committed during World War II. And they did not explicitly address sexual violence as a distinct category of war crime. The result was a legal architecture that could acknowledge the starvation of prisoners, the use of forced labor, the systematic execution of captured partisans, but not the systematic rape of women held in rear area detention, because rape, in the legal language of the time, was not considered a weapon of war. It was considered a crime of individual moral failing. It was categorized alongside theft and drunkenness, misconduct, not policy. This categorization had consequences. In the 1950s, as West Germany began prosecuting war crimes through its own courts, cases involving sexual violence were rarely brought forward. When they were prosecuted under domestic criminal statutes, assault, kidnapping, bodily harm, not under international humanitarian law. The sentences were correspondingly light. a former Wehrmacht officer convicted of detaining and assaulting a Polish nurse in 1943, received 18 months in prison, suspended. The judge noted that the officer had been under significant stress due to partisan activity in the region. The woman was not present at the trial. She had not been located. In East Germany, Soviet authorities conducted their own trials, but the focus remained on crimes that fit the narrative of fascist barbarism: mass shootings, concentration camp operations, the burning of villages. Sexual violence was mentioned in testimony, but it was treated as incidental, evidence of the general depravity of the enemy, not as a distinct and prosecutable category of crime. The women themselves, those who survived, learned quickly that testimony was not the same as justice. Many did not come forward. Many who did found themselves subjected to interrogations that focused not on what had been done to them, but on whether they had resisted sufficiently, whether they had been in positions where such treatment was expected, whether their conduct before capture had been appropriate. The legal system, even when it acknowledged their suffering, demanded that they prove their innocence. This was the structure Magda Reiner had participated in, not through malice, but through compliance. She had been a small part of a large machine, and the machine had operated exactly as it was designed to. But small parts can jam machines. In 1998, the International Criminal Tribunal for the former Yugoslavia issued a landmark ruling in the case of Prosecutor v. Anto Furungiga. The tribunal found that rape constituted torture under international law. It recognized that sexual violence could be prosecuted as a war crime, a crime against humanity, and an act of genocide if committed with the intent to destroy a protected group. The ruling cited precedents from Nuremberg, but not the cases that Magda had erased. Those cases were not precedents; they had never been tried. Instead, the tribunal relied on legal scholarship that had slowly, over 5 decades, built the argument that sexual violence was not incidental to war but intrinsic to it, that it was used systematically to terrorize populations, to destroy social bonds, to assert dominance, that it was, in every functional sense, a weapon. The shift in legal recognition came too late for the women whose testimonies Magda had copied. Most were dead by 1998. Those who were alive were in their 70s and 80s, living in countries that had collapsed and reformed, borders that had been redrawn, under governments that had no interest in revisiting the crimes of a war that had ended before many of their citizens were born. But the shift mattered for what came after. In 2008, the United Nations Security Council passed Resolution 1820, explicitly recognizing sexual violence as a tactic of war and a threat to international security. In 2018, Nadia Murad, a Yazidi woman who survived sexual slavery under ISIS, was awarded the Nobel Peace Prize for her advocacy. The language she used in her acceptance speech, "I was a victim, now I am a witness," was a direct challenge to the legal systems that had, for so long, treated victimhood as disqualification from credibility. And in 2021, a German court in Koblenz convicted a former Syrian intelligence officer of crimes against humanity for overseeing torture and sexual violence in a Damascus prison. The conviction relied on testimony from survivors who had fled to Europe. The trial was conducted under the principle of universal jurisdiction, the legal doctrine that certain crimes are so grave that any nation can prosecute them, regardless of where they occurred. It was the kind of case that could not have been prosecuted at Nuremberg, not because the law did not exist, but because the will did not. Magda Reiner's transcripts resurfaced one final time in 2014, when a doctoral student at Humboldt University in Berlin was researching the administrative structures of the Nuremberg tribunals. The student found references to the transferred files in internal memos and traced the logistics of their disappearance. She located the 17 depositions Hoffman had published in 1974. She attempted to locate the remaining 56 that Magda had copied. None were ever found. The student's dissertation concluded that the exclusion of sexual violence testimony from the Nuremberg record was not an oversight. It was a policy decision, shaped by gendered assumptions about credibility, legal frameworks that devalued crimes against women, and political priorities that favored expedient justice over comprehensive accountability. The decision had been executed by clerks, translators, and low-level administrators who were following orders. But the orders had come from attorneys who understood exactly what they were doing. One of them was still alive when the dissertation was published. He was 93, living in Virginia, a retired professor of international law. He was asked, in an email interview, whether he recalled the decision to exclude female combatant testimony from the prosecution's case files. He replied, "We made many difficult choices under immense time pressure. The priority was to hold the Nazi leadership accountable for industrial-scale atrocities. We succeeded in that. Regrettably, not every crime could be prosecuted. That is the nature of justice in the aftermath of total war." He did not address the word regrettably. He did not explain why some crimes were prosecutable and others were not. He did not acknowledge the women whose testimony had been deemed insufficient. But history does not require acknowledgement to render judgment. The Nuremberg Tribunals are remembered as the foundation of modern international criminal law. They established that individuals, not just states, can be held accountable for war crimes. They codified the principle that following orders is not a defense. They created a legal vocabulary for naming atrocities that had previously existed beyond language. But they also established a template for selective justice. They demonstrated that legal systems, even when constructed in the name of universal human rights, will reflect the biases of those who build them. They proved that documentation is not the same as truth, and that evidence can be silenced as effectively by filing it away as by burning it. Magda Reiner understood this. She had operated the machinery of that silence, and then, 23 years later, she had broken it. Not loudly, not publicly, not in time to change the outcome of the trials or secure justice for the women whose words she had copied, but enough to ensure that someone, eventually, would know what had been done. The question that remains is not whether the system failed. The question is whether the system was designed to fail in precisely this way. Legal scholars who study Nuremberg often frame the exclusion of sexual violence testimony as a product of its time, a reflection of 1940s attitudes toward gender, combat, and credibility. This framing is accurate, but it is incomplete. It treats the decision as passive, as though the prosecutors were constrained by cultural naces they could not see past. But the internal memos, the logistical protocols, the careful routing of testimonies through administrative channels designed to remove them from the active docket, all of this required deliberate action. It required someone to recognize that these testimonies existed, to evaluate their content, and to decide they were unsuitable for prosecution. That is not blindness, that is choice. The architects of Nuremberg understood that the tribunal would set precedents. They knew that the cases they brought, the evidence they presented, the legal arguments they constructed would shape international law for generations. They chose to build a framework that prioritized crimes of industrial scale, genocide, mass deportation, the machinery of extermination, because those crimes were undeniable, because the documentation was overwhelming, because the moral clarity was absolute. They chose to exclude crimes that occurred in the gray zones of irregular warfare, crimes that lacked clear command authorization, crimes whose victims occupied ambiguous legal categories. And they chose to exclude crimes against women because those crimes were, in the calculus of post-war justice, expendable. This was not an accident of history, it was an expression of values, the same values that allowed military planners to categorize rape as collateral damage rather than as a tactic, the same values that treated women in combat as anomalies rather than as combatants, the same values that assumed credibility required uniformity, documentation, and the endorsement of a recognized state. Magda Reiner's act of preservation was not heroic. She did not expose the system. She did not stop the suppression. She copied 73 documents out of more than 2,000 that were buried. She mailed them anonymously to a historian 2 decades later. She never testified. She never went public. She never attached her name to the revelation. But she ensured that the silence was not complete. In the decades since, other archives have opened. Soviet records, declassified in the 1990s, contain hundreds of additional depositions from female combatants and partisans. Polish archives hold testimony from women who survived detention in re-area facilities. Yugoslav, French, and Greek archives contain fragments of similar accounts. Researchers have begun to reconstruct what was erased, not perfectly, not completely, but enough to establish the pattern. The pattern is this: across every theater of the Eastern and Southern European fronts, women who fought, who resisted, who served in auxiliary roles were captured, detained in makeshift facilities, subjected to systematic sexual violence, and then either killed or reclassified as civilian laborers. The practice was widespread enough that it appeared in the war diaries of multiple Wehrmacht divisions. It was routine enough that it required no special authorization. It was invisible enough that it left almost no trace in official records. And when the war ended and the victors sat in judgment, they decided that this pattern was not worth prosecuting. The legal justification was narrow. The women were not uniformed combatants, so the Geneva Conventions did not apply. The political justification was pragmatic. The tribunal had limited time and resources, and these cases were not central to the indictment of the Nazi leadership. The moral justification was never articulated, because moral justifications are not required when legal and political rationales are sufficient. But the effect was total. An entire category of victims was written out of the historical record of the war. Their testimony was deemed inadmissible. Their suffering was deemed irrelevant. Their names were replaced with reference numbers, and then the reference numbers were misfiled, and then the files were lost. This is how systems of justice become systems of erasure. It is not through malice, though malice exists. It is not through conspiracy, though coordination exists. It is through the accumulation of small, reasonable-sounding decisions made by people who believe they are doing their jobs. The prosecutor who decides a case is too weak to bring to trial. The clerk who transfers a file to an auxiliary archive. The archivist who marks a box as non-essential. The historian who concludes that documentation is too sparse to support a chapter. Each decision is defensible. Each decision is procedurally correct. And each decision participates in a structure that ensures certain voices will never be heard. Magda Reiner broke that structure in the smallest possible way. She took documents that were supposed to disappear and made sure they didn't. She did not change history. She did not secure justice. But she created a record. And a record, even a fragmentary one, even one that arrives decades too late, is a form of resistance. Because the alternative to a record is not merely forgetting. It is the claim that nothing happened, that the women who testified were unreliable, that the crimes they described were isolated incidents, unprovable, unverifiable, unsuitable for the machinery of law. The record refutes that claim, not by proving every individual case, many will never be proven, but by demonstrating that the testimony existed, that it was collected, that it was evaluated, and that it was deliberately excluded. The absence of justice was not an accident, it was a policy. And policies can be challenged. In the 76 years since Nuremberg, international law has evolved. Sexual violence is now explicitly recognized as a war crime, a crime against humanity, and a component of genocide. The legal void that allowed the exclusion of female combatant testimony has been partially closed. Universal jurisdiction allows national courts to prosecute international crimes regardless of where they occurred. Victim testimony is no longer automatically discounted on the basis of gender or combatant status. But the evolution of law does not undo the past. The women whose testimony Magda copied received no justice. The men who detained them, who assaulted them, who erased them from the record were never prosecuted. Most lived full lives, many receive pensions. Some wrote memoirs in which they described the war as a tragedy, a failure of leadership, a catastrophe that consumed an entire generation. They did not mention the women in the sheds and barns and cellars. Those women were beneath the threshold of memory. Magda Reiner's transcripts are now held in the Institute for Contemporary History in Munich, in a climate-controlled archive on the third floor. They are available to researchers by appointment. They are cited in dissertations and journal articles. They are footnotes in the larger history of the war, small data points in the vast accounting of atrocity. But they are also something else. They are evidence that someone, in a room that smelled of mimeograph fluid and old wood, in a moment when it would have been easier to do nothing, chose to make a copy, chose to take it home, chose to keep it hidden for 23 years, chose, finally, to send it into the world without a name attached, without credit, without certainty that it would matter. That is not heroism, but it is not nothing. It is the small, unglamorous labor of preservation, the refusal to let silence be total, the insistence that some things, even when the world has decided they are inconvenient, must be remembered. And in the end, that may be the only justice the women in those transcripts will ever receive, the knowledge that their words survived, that someone listened, that someone believed them enough to risk carrying their testimony forward across decades, across borders, across the chasm between what happened and what was officially recorded. The heating pipes still knock in the Palace of Justice in Nuremberg. The courtrooms are museums now. Tourists walk through the halls where the architects of genocide sat in the dock, where prosecutors presented mountains of evidence, where the world tried to build a system of justice strong enough to prevent the next atrocity. But in the basement, in boxes that were never properly catalogued, there are gaps in the record, files that should exist but don't, reference numbers that lead nowhere, testimony that was taken, logged, and then lost. Magda Reiner filled 73 of those gaps, the rest remain empty, and the women who could have filled them are gone.